Hi guys, it's Kathy. I hope you're doing well. Time to go back to OJ. I really think that we should be done with Cochran's opening statement today. I can't promise anything because man, that man can talk. They can all talk. Hi Lori. But he's been talking for a long time. So I think today's the day. I can't wait for the opening statements to get over with so that we can get people on the stand. All right. Got a new cup of coffee and we're ready to go. We're ready to go.
What's your homework? Mr. Douglas, why don't you put yours up? Now, before we go into the timeline, we'll talk more about this, and you'll hear more about this when we discuss so-called alibi testimony. One of the things that I expect the evidence to show in this case is that Mr. Simpson does, in fact, have an alibi for his whereabouts on that particular night during the critical time. You'll recall that the prosecutors in their opening statement talked about the period of time between 9:45 and about 11. So our evidence here this afternoon will track that same period of time, 9:45 p.m. till about 11.
Yo, guys, imagine if Bill was OJ's lawyer. The jury would get 3 words the whole trial. He is innocent. And that would be it. Trial over. Acquitted.
11 o'clock p.m. And you'll recall the testimony that you've heard so far.
Bill, are you northern, middle, or southern Florida? And are you getting snow? American Courts. That's Bill. Bill is American Courts. He has the best channel on YouTube. He's the king of YouTube. He gets to be in the 8 o'clock time slot because he's the king of YouTube. What is in my coffee? Bill, are you northern, southern, or middle Florida? I need to know if Florida's getting snow. Someone in my last stream said something. They said a storm was coming. A winter storm was coming to Florida. Never snow. Okay, no snow for you. No snow for you. I'll keep the snow here.
Miss Nicole Brown Simpson spoke to her mother and an individual at the Mezzaluna restaurant, certainly in the area of 9:42 or thereabouts, at 2 phone calls in that period of time. So it's reasonable to assume that she certainly was alive at that particular point in time. So that's probably a very good starting point. What you have on the board, and this number, Mr. Douglas, what's his number again? 213. All right, this is 213. This is a view, a side-by-side view of each of these residences side by side. What we're going to do is we're going to start at 9:45, and in each instance for Rockingham and for Bundy, tell you what we expect the evidence to show of the various parties and where they were. Let's take the graphic on the board. And what's that number, Mr. Harrison?
107.
Thank you. 9:45 at the Rockingham residence, Mr. Simpson's. You'll see in this thing, we think the evidence is going to show that Cato Kalin is in his quarters, Mr. O.J. Simpson's in his quarters, and to the right here is Rosa Lopez. And you'll see this area. Let me just use this as an example. Hold the camera. I think the evidence will show that the side of the house, Rosa Lopez lives right over in this part here, but there is this side of the house, a little walkway that goes right down the side of the house, back this way. And that's where Detective Herman claims he found the glove in this very small area. It leads back out here somewhere. So 9:45 at the Rockingham residence.
Wait, so they had a KK over here and an OJ over here. But in all the other pictures, KK was way over here, wasn't he? I'm just going to bump it back a second. I know it's not going to work well. Okay. What? That makes 0 sense to me. Because in all the other pictures, like the main house was here. And wasn't KK over here? let's just keep going.
This way. That's where Detective Furman claims he found the glove in this very, very small area. It leads back out here somewhere. So 9:45 at the Rockingham residence, you see the parties who are there. Mr. Douglas has charted that on the chart here. You can see it in both places. Mr. Harris, the next one.
E109.
All right, at 9:45 or thereabouts at Bundy, you'll recall this is the residence right there on Bundy. And we know from expected testimony to be that Mr. Cole Brown Simpson had a phone conversation with her mother and with somebody at the Metzaluna restaurant about having the glasses which the party had left at Metzaluna. We expect she's still very much alive at that particular time. Mr. Harris?
E110.
We're taking this in 5-minute intervals, and obviously these intervals of this, because you're doing it within 5 minutes, it's not exact, but it's as close as we can approximate based upon the evidence as we now understand it. At 9:50, parties in their same relative positions, Rosa Lopez, Mr. Simpson, Mr. Cato Kalin still inside his residence. 9:50,
111.
number 111, same situation with regard to Bundy.
E112.
9:55. Again, now keep in mind that the testimony will be that Rosa Lopez at about 8:15, between 8:15 and 8:30, has come out. She's seen this Bronco parked there. She's walked her dog somewhere back in this area over here that I'm indicating with the light, and she sees the Bronco kind of parked somewhat askew. And 9:55, this is the relative positions that we think the evidence will show the parties at Rockingham at that time.
E113.
9:55, nothing else has changed at the Bundy scene at that point. Mr. Harris?
E114.
At 10 o'clock, this is at Rockingham, and at 10 o'clock, for your attention, I think you'll find there'll be testimony that the Bentley, of course, that Mr. Simpson and Mr. Cato Kalin had gone to get the McDonald's, the hamburgers in, parked in the yard there. That Cato Kalin is taking his food back to his room to eat. That they'd gone somewhere around 9 o'clock. They got back somewhere around 9:37 to 9:40, somewhere in that area. Bentley was parked. Mr. Simpson had eaten his hamburger. Rosa Lopez remains at the same place. And we've drawn in, based upon what we expect the testimony to be, the car on the Ashford side here, the Cato Kalin's car. It's all in black there. And you see, of course, the Bronco. That's the 10 o'clock scene as we expect the evidence to show at Rockets.
E115.
Now at Bundy at 10 o'clock, we expect there will be testimony that a man named Tom Lang, same name as the detective in this case, but not the detective, a witness, we think will testify that he's out, as so many people in this neighborhood do, walking his dog down here. There's a street down here called Dorothy Street. There's this dog, and he's out walking the dog, and that he makes a statement to the police, which he tells the police that he sees a lady who fits the description of Nicole Brown Simpson wearing something black, some kind of a black dress. The detective who takes the statement down, the evidence will show, miswrites it and puts it like a white flowing dress. But he tells him black dress, I think the evidence will show. But he sees from this location down here, he sees this lady whom he believes is Nicole Brown Simpson, either touching or in some way embracing someone at a car parked at this curve, right about in this area here. And he is south of their location, and he sees a gentleman at the car, and he sees Mr. Cole Brown Simpson. What he also sees, he sees a man he describes as a Hispanic gentleman standing on the sidewalk beyond where Mr. Cole Brown Simpson and this gentleman are, and he is standing with his fist clutched, as I'm indicating for the record, staring down at Mr. Lang. He thinks this man may be angry with him because his dog is loose or whatever. So that's Mr. Lang, and that's 10 o'clock at that, and this is the residence here, that's 10 o'clock at the Bundy Street location. And if Mr. Lang, of course, is correct, and Nicole Brown Simpson is still alive, of course, at that point. At 10:05, at the Rockingham residence, Mr. Simpson has come outside the house. Mr. Simpson, I think the evidence will show at some point, made a telephone call somewhere between 10 and 10:05 to his then girlfriend Paula Barbieri on a portable phone that he'd had in this Bronco. There was a phone call. He was unable to hook up with her, but he did in fact make this phone call. I think there'll be records or whatever that affects. So at 10:05, that's the situation there with Cato Kalin still being in his room and Rosa Lopez still being at her location.
D116.
10:05, we still have the same situation at the Bundy location. We have Tom Lang still at his same approximate location as we described. After making the phone call at the Rockingham location, we now have Mr. Simpson back inside. Mr. Simpson very often will swing golf clubs, which he keeps all over the place, in Bentley, in the garage or whatever, if the evidence will be, and that he sometimes will chip. For you, those of you who are golfers, he'll chip or swing his 4-wood or 3-wood, generally over in this direction over here, where there's some sand where the kids can play and that sort of thing. But during this period of time, Mr. Simpson, at some point, swings his golf clubs or whatever, and at some point, at this point and later, chips, so he's out in this yard area after having made the call.
D118, D119.
10:10, not much happening at the Bundy that we can tell.
D120.
All right, after Mr. Simpson has done that and been outside, make his phone call, I think then you'll find the relative positions of the parties. Simpson back inside the residence. The evidence will be he's going to Chicago. At some point he has to pack, get ready. Cato Kalin's in his room. And Rosa Lopez still at her location.
Come to my bar, I will get you drunk. If you're going to stay at a hotel, stay at the one right beside my bar. That way I can get you drunk and you can just walk back home.
At that point, where she's just about to leave.
D121.
Same situation at 10:15 at the Bundy location.
D122.
This location at about 10:15 to 10:20, Rosa Lopez then comes outside of her location to walk her dog again. And she comes out in this general area to the right here on Rockingham. We expect the testimony to be that Rosa Lopez sees the Bronco still parked the same configuration, the same location, just like she had seen it between 8:15 and 8:30. She sees it between 10:15, 10:20, the same location. And we think she'll also testify she saw this same Bronco parked in the same manner, same location, same configuration the next morning after she had talked with Detective Furman. That's Rosa Lopez at 10:20, thereabouts, at Rockingham.
D123.
At 10:20, contrary to what you've been told, I think, by the evidence by the prosecution that they can determine death by the plaintiff wail of a dog, we have some live witnesses, Ellen Aronson and Dan Mandel, some two that I alluded to earlier, who've been apparently on this date to Metzaluna, and they're walking home. They're walking down Bundy from north to south at about 10:20. They walk north to south. This location is I've indicated here. Thank you, Mr. Harris.
D124.
At the other location at about 10:25, we expect that Rosa Lopez at the Rockingham is certainly going back inside the residence now, having walked the dog. Mr. Simpson inside the residence, Cato Kalin inside the residence, and we have now for the first time the limousine driver, Alan Park, who comes up. And it's interesting if can you back that up for a minute, Mr. Harris? Interesting at the 10:25 location, and you'll recall because I read you the testimony of Alan Park at both the preliminary hearing and the grand jury that he didn't see or didn't look to see any other cars. Ms. Cato Kalin's car was there. He didn't look to see his Bronco was down there. And you will hear evidence, I'm sure, with regard to whether or not, what about the streets at that time of night, 10:25, 10:30 on a Sunday in Brentwood? What might you expect to hear? Were there lights on? What would be observable at that location? I believe, hopefully, we'll be able to go out to these scenes at night also. So we have Cato Kalin's car, Alan Park's limousine, and the relative positions of the other parties. We'll go now back to Bundy.
D125.
Now by this time, according to what I expect the testimony to be, Ellen Aronson and Dan Mandel have continued.
I got a new chef coming in today, but he's one of my uh, he's not my best friend, but I'm very close to him and his wife. So when a restaurant gets a new server, a new dishwasher, um, a new line cook, it's not a big deal. Things go the way they go. When we get a new chef, that changes everything. The entire restaurant changes. He's going to bring in his new menu. He's going to bring in his new ideas about how things should run. Um, Now, normally, back of the house deals with back of the house, and front of the house is separate. So I don't see him interfering with me very much. We're a team. We need each other. So we're going to find out how it works today. Now, I believe the owners are phasing themselves out of the business, and he's going to take on more of a management role. So then he will interfere with the front. But I've been doing this for many, many, many years, and so is my other server. And I can't imagine him messing with what we're doing up there because it's really perfect. It really is. I know it is. So he should just leave us do our thing. I mean, it would be smart to let us do our thing. We buy the cleaning supplies. We buy the decorations. We do everything in the front of the house. We make sure that there's customers in there every day. We're nice to the customers. We make sure the other servers are nice to we know what we're doing. So new chef should be fine. I should be perfectly fine. I know what I'm doing. He doesn't need to bother me up front. Oh, except for my broom. It's very important to me that I have a broom. Not because I'm a witch, but because we work in a restaurant, people throw food on the floor all the time. The last chef said that we can't have a broom out front because it looks like a diner or something, a trailer park. So they took our broom, and I let them. I'm like, screw it. If you don't want me to sweep the floor, I won't sweep the floor. So I never swept the floor. The floor had food on it until the end of the day, and that was their decision. Screw it. I don't care. It's not my restaurant. But now I can have my broom back. Because Dave's going to know that a French fry is a slip hazard and can't be on the floor. Okay, go Birds. I'm on the Birds team now.
Continued walking south on Bundy, and now they are right in front of the residence there at Bundy. And the importance of this, we think the evidence will show, that they walk there in this very short distance, right to their right, if the crimes had occurred, would be these bodies with the gate open, with blood flowing down. You remember when I read this morning from Phillips's transcript, when he was talking to the coroner about the need to come out there. These bodies are right there. They can be seen from the sidewalk or from the street. So these people are in a rather unique position. I believe that their testimony will be they saw no bodies, they saw no gate open at that point. It was approximately 10:25 when they're walking at this particular location. So they become, as with all witnesses, very important. They become particularly important when the prosecution tries to present a theory that these killings had occurred at 10:15.
E126.
Back at 10:30, we have Rosa Lopez go back to her house. Everybody else in their same positions. Park is still out with the limousine. In fact, Park has at some point gotten outside the vehicle. If the testimony will be, and he's somewhere out here on the Ashford side of the residence.
E127.
10:30, I think we now have Robert Heidstra, who is in this alley. I described for you before an alley that runs parallel to Bundy, and this will be measured for the distance between this alley and Bundy there. But he also is out walking his dog on this Sunday evening. He's walking in this direction, again apparently from north to south. And it's about 10:30 that he first appears.
E128.
10:35, the situation is still pretty much the same at this point. The limousine driver is early. The roles of the various people appear approximately the same, 10:35.
E129.
10:35. Now you'll recall that Ellen Aronson and Dan Mandel have walked past this location at about 10:25. They don't see any bodies or gates or any blood. Now this man, Robert Heistra, is in this alleyway. I believe the testimony will be that at 10:35 or thereabouts, he hears some unusual things. He hears the sound, hey, hey, hey. He hears, I believe you'll hear, a gate clanging or closing. There will be testimony there are gates back this way at the Nicole Brown Simpson residence, in addition to one in the front. That he hears the sound of men arguing. I believe is what the testimony will be. So from this location, he can hear this. He hears this going on. He hears that to be at about 10:35 p.m. That's at the Bundy location. He's in the alleyway, and he's approximately parallel to the Bundy location, except he's in the alleyway off of Bundy. It's at 10:35.
E130.
We know that, according to the testimony of Mr. Park, at some point, about 10:40 or thereabouts,
That is good advice.
pulls the limousine around. He's been trying to get contact with someone. He pulls around up to the Rockingham gate, which is on this side, as opposed to the Ashford gate, which is on this side, and then he apparently then goes back. You know, having heard his testimony read at both the preliminary hearing and the grand jury, not looking for and cannot tell us either way whether the Bronco is there or not. He goes back to this location, and that's about 10:40 or thereabouts, the Rockingham.
E131.
All right, 10:40, we have Mr. Heistra still in this alleyway, in this area. This is approximately the time at 10:40 p.m., June 13th, that he hears this confrontation, supposedly with these men's voices, the sounds, etc., the distance that he's away.
E132.
All right, at 10:45, there'll be testimony, I believe, that Allen Park is up to the gate at this point, that you see the location of the other parties, their location. He's closer to the gate with the car right at the gate. You see the parties of the position of the other parties at that time. He's moved his car back from down at the Ashford gate back around. It's 10:45 or thereabouts.
Okay. You know how I said I thought maybe he would be done speaking today? Maybe I'm wrong, guys, because it's already been minutes and he's still talking.
E133.
10:45. This is the journey of Mr. Heistra as he's continued down this alleyway. See where he's gotten now as he's walking the dogs. And he's still walking parallel to the residence, having made the observations that I've shared with you earlier.
E134.
10:50 or thereabouts. Mr. Simpson, the evidence will show, has come outside of his residence. He's gone over to the Bentley at that point. Look inside the Bentley, and this location here, it's a white car, a white indication there. That's supposedly Bentley at that location. Simpson's outside the residence. Park is over at the gate. Lopez is back in her residence. Cato Kalin is still somewhere back in his quarters, apparently, at that point.
E135.
10:50 now at the Bundy address, and the witnesses at this particular point.
E136.
Now, 10:55. We now have Mr. Simpson having been or done whatever he's doing in the area of the Bentley, going back over toward his house, to get his luggage and come down to get ready to leave. You have Cato Kalin coming out, presumably because he's heard whatever noises. He's now outside of the location. Allen Park is still over here. There's some testimony. There'll be some golf clubs or whatever out here in this area of the yard in this area here. All at Rockingham. This is approximately 10:55.
I just sneezed. Now he's going to have to explain the DNA all over again.
Just before 11.
E137.
The scene remains pretty much the same. Robert Heistra is now out of the scene here at Bundy.
E138.
11 o'clock, Allen Park is let in. Your testimony, I think, will be that you start to load the limousine up, which is now inside here. Cato Kalin is having conversations with O.J. Simpson about noise that he's heard. He's trying to get a flashlight. He's trying to tell Mr. Simpson about what he thinks he's heard. Mr. Simpson is rushing around at this point. At some point, he goes back out. He goes to the Bronco at some point. Comes back in, gets his luggage, and brings his luggage down, a number of pieces of luggage which you'll hear about, and all of these people are in and around 11 o'clock and thereabouts are in this particular area here, as depicted on this exhibit at Rockingham. Mr. Harris?
Before we answer that, John, what do you think? John, if you had a guess if we were in trial yet or this is the opening statement, which one do you think we're still in? Which one? Come on. Don't anybody say it. Don't anybody say it. We want to know what John thinks first.
The situation remains the same at Bundy. And so at Bundy, no other witnesses at this point. Sheriff, will you go back to Rockingham at 11 o'clock? Cato Kalin's car
Then
remains
it
in the
must
same
be
place.
opening statement.
The limousine is now closer in the Ashford Gate. Bentley is still where it is. Bronco is still where it is. Ms. Lopez is in her residence. Kalin, Mr. Simpson, at or around this area with Mr. Parks. As I've indicated, this is the time that they're preparing to go on this pre-scheduled trip to the airport to go to Chicago. Around this time or thereabouts, Mr. Simpson has come out and gone out to the Bronco, and then he comes back in also at that point. I've taken this from 9:45 until 11 o'clock because that's the time the prosecutor referred to and talked to, and I think it probably is the very appropriate time for us to look at. In discussing this particular timeline, I tried to demonstrate for you the witnesses that we expect will be called, what they have to say about this particular period of time. In listening to the prosecution's opening statement, they claim that Mr. Simpson left the Rockingham location, traveled to Bundy, killed two people with one knife, hid the bloody clothes, and returned to Rockingham. He did all this at about 10:15 or 10:15 and got back there at 10:25 or 10:30 or something of that nature. In a short period of time, that's what their theory was. We think that they have further, based upon their opening statement, committed themselves to a theory that in traveling to and from Bundy, Mr. Simpson had used this Bronco that you've heard so much about. So therefore, wherever that Bronco was that night, then according to their theory, that's where Mr. Simpson was that particular evening. What we tried to demonstrate for you in the evidence, we think will show, there's not that window of opportunity. There's not the time in which they can prove that Mr. Simpson committed these horrible crimes. They don't have the time, the opportunity, nor the motive to establish this. We think the evidence will show that he did not, could not, and would not committed these particular crimes. Now, in the course of this trial, you will hear some testimony regarding domestic discord, domestic violence, if you will, about what happened. I touched upon that briefly the other day. Without belaboring the point, and as you hear this testimony, I ask you, as with all of the evidence, to keep an open mind, to remember that the incident, January 1st, 1989, was the assaultive incident that Mr. Simpson took blame for, wrote letters of apology. And you recall the testimony we expect to be she was never struck after that in any physical sense, and that, in fact, he made an agreement regarding the prenuptial agreement, that if there was any physical touching, the prenuptial agreement would be voidable at any rate. That was never done. And we expect to show that with regard to this entire domestic discord evidence, that there will be, and I ask you to bear in mind, in many instances, where there are more than one person present.
Yep, Kardashian.
Please keep an open mind until you've heard the other people who are also present at these incidents, so you can make a determination of whether this has any bearing at all. Because if you follow the evidence, and if you believe that Mr. Simpson could not have done this, that this timeline is such that there's no time for him to do it, no indication that he could have done this, that the Bronco was still there, whatever, then the character evidence would mean absolutely nothing. Because how could you then predict that someone who gets into a fight with his wife in 1989 will then kill her in 1994? One area that I did not cover earlier is the searching done in this case. They've searched everywhere in this case for weapons and or closed, and I think the evidence will be that they searched even in Chicago, in the fields, in the wooded areas in Chicago, all up and down Rockingham and Bundy and every place they possibly could. They worked very hard on this case because in their rush to judgment, they fixed on this one individual, and that's what they focused on, and we think the evidence will show that that's exactly what they did. Ms. Clark in her opening statement said that Mr. Simpson's time was unaccounted for, quote her, from 9:45 till 11. I think you'll find when you hear the evidence that he spoke to the police. This time is not unaccounted for. The time will be accounted for. Can I conclude, Your Honor?
Now I want you to approach the bench with the report, please.
Now, I think when we stopped, I was addressing the issue that we think the evidence will show that Mr. Simpson's time will be accounted for and not unaccounted during this particular period from 9:45 to 11 o'clock. In looking at my remarks the last time I spoke to you, I noticed that I misspoke when I said at one point that Dr. Kerry Mullis had won, I think I said, the Nobel Peace Prize, and I think I must have had Dr. Martin Luther King on the mind when I talked about him. He won the Nobel Prize for chemistry. I want to clear that up. When I was addressing you about the prosecution's theory a few moments ago in this case, I recall that Ms. Clark had indicated that the time of death was 10:15 based upon the wail of the dog. As to the time she alleges that Mr. Simpson got back to the premises, that'll be up to her to prove, and I suppose that I shouldn't speculate with regard to that. Now, I'd like now for Mr. Douglas to bring some charts up that relate to certain jury instructions, which I think would be very appropriate for you to have in mind, as with all of the jury instructions that the court has given you, with regard to the evidence in this case and how you're going to go about your task of rendering a decision now that you have an overview of this evidence. We'll have 4 charts that I'd like to step down. Now this chart is 2.20, which is the CalJIC, the jury instruction. I think you've already heard it. And the reason I wanted to point this out to you again is that as in this case, in all criminal cases, this is kind of a guide for you to look at the witnesses who get on the witness stand to help you in determining whether or not you find that particular witness to be credible or believable, if you will. And they set out certain things that you might look at. Look at things like the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of the testimony of that particular witness, the demeanor, how that witness acts on the stand, and the manner of that testimony, the existence or non-existence of a bias. Does the witness have any interest or bias in this particular case? So the attitude of the witness toward this action will be things that you'll look at. And the court has read this to you. The character of the witness for honesty or truthfulness, or any statement previously made or whatever. These are the things that I would ask you to use with regard really to all witnesses called by prosecution or the defense. Remember, the no side has a claim to the truth in this case. As we go about this search for truth, people have been talking about. The next jury instruction, and that is number, Mr. Douglas, number. Get the number, Your Honor. Okay, like that, huh? Number 215. And number 215 is the so-called alibi instruction. And you'll recall that I asked you in voir dire a long time ago that you would not put any bad connotation on the term alibi if that's what the law called it. That no matter who is charged with a particular offense, if you were someplace else, you produce evidence that you were someplace else, the law calls that an alibi. And essentially this instruction says that the defendant in this case actually will be introducing or expects to introduce evidence for the purpose of showing that he was not present at the time and place of the commission of the alleged crimes in this case for which he's here on trial. But if after consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Now again, this instruction is important like all the rest. But the alibi instruction, if you establish the alibi to your satisfaction, be entitled to an acquittal under those circumstances. I'd ask you to think about that through the coming months as you listen to this evidence.
Exhibit 216.
Mr. Douglas? You recall all of the examples we used during voir dire again about direct and circumstantial evidence. Well, in the final analysis, this is a case that will rest primarily on circumstantial evidence, and you know what that evidence is. And this is your instruction that applies to that. It's extremely appropriate, and I think I applaud Judge Ito for having given you this instruction early on, because I think it's very, very important for you to be aware of this as you consider this evidence, especially circumstantial evidence, and how it will be applied at the very end of this particular case. This is part of that instruction, and the relevant portions would be as follows: that a finding of guilt as to any crime may not be based on circumstantial evidence, unless the proof circumstances are not only one, consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, there are two counts here, susceptible to two reasonable
They would have showed he was in the area at the time.
interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. So after you listen to this evidence, as we think the evidence will show, you have a belief that Mr. Simpson did not go back over to that location, didn't go to the location, that he was never, Bundy didn't, strike that his Bronco never left the premises that night based upon. Well, let me phrase it this way. If she's
Please.
not right, Your Honor.
And
You
the
got-
fact the instruction is not ready for you.
I'm gonna get it. If after you heard all the evidence, and you know what circumstantial evidence is, you will then be in a position to make a judgment as to whether it applies at this particular point. Without arguing what it is now, we'll have a chance to argue at a later time. But the point that I wanted to make at this point is for you to understand what this instruction would be as the court has. And lastly, as Ms. Clark points out, if on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. It seems reasonable, doesn't it? But the point is that you, no one else, will be the sole and exclusive judges of the facts and the weight of evidence. That's the determination that you must make. And no one can tell you what to make in that regard. And each of you in voir dire has promised to give us your individual opinion in doing that. And the last jury instruction
Exhibit 217, Your Honor.
is the so-called presumption of innocence, reasonable doubt, burden of proof instruction. It's the last instruction I want to leave with you today. A defendant in a criminal action is presumed to be innocent until the contrary is proved. In the case of a reasonable doubt, whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. And this presumption, of course, as you know, places upon the people the burden of proving him guilty beyond a reasonable doubt. And reasonable doubt has been defined as follows. It's not a mere possible or imaginary doubt, because everything relating to human affairs, depending upon that everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where, after the entire comparison and consideration of all the evidence leaves the minds of the jurors, in that condition that they cannot say, they feel an abiding conviction of the truth of the charge. Now that's what reasonable doubt is in this case, in every case. And I wanted to make sure that you again are aware of that as you listen to this case. This is a murder case with two charges, two counts. This is not a domestic violence case. Now, as we conclude, and finally, as I promised you today, I believe
I didn't hear him. I didn't hear him exactly. I think he just said he was concluding. Did he say he was concluding? Oh my God, I'm so excited. Thank you, Johnny. Thank you.
the evidence will show that
What happened? Oh gosh, you're right. Why did they just stop?
We expect also that there will be evidence and testimony that a short time before Mr. Simpson went to Chicago on Sunday evening, June 12th, I think on or about June 2nd, his secretary, at his request, ordered this Star 69 feature at his request on his phone. And we expect there'll be additional testimony about.
Yo, Star 69. I used to do that all the time. Who called me? Star 69. Who is this? I miss Star 69.
That and as to why that was. In summary, as you then look at all the evidence in this case, we expect the evidence will show that O.J. Simpson, as you see him there, is not a perfect human being. He, like all of us, has made mistakes. Of course, we know there's only one perfect person who ever walked the earth. We think the evidence will show he's not guilty of these horrible crimes, that he has been blessed
My
bountifully
ex-husband
by
thinks
God,
he
and he
was him.
shared his largesse and blessings with many, many people. That in this instance, prosecutors' theory that there was only one murderer is just theory. We expect to introduce evidence to show there was more than one killer, and that the prosecutor's theory will be overcome by the facts which we present. We also expect that the evidence to show that the reason the prosecution maintains there's only one killer is that Mr. Simpson, whom they want to portray as a stalker, and stalkers don't come in pairs. There can only be one person under that scenario. That ex-husbands who are stalkers don't come in pairs, and that's why they're wedded to this one murderer theory, even contrary to what their own coroner may very well indicate. I've shared with you also the fact of Mr. Goldman's journey that evening, and when he checked out and went home and changed clothes and everything, so I will not belabor that. We expect there'll be evidence about how you get into 875 South Bundy when one comes up and rings the bell or whatever, how you get in from the house, or whether that's possible, whether somebody has to let you in, or how you get in the particular residence. I've already told you we expect there will be evidence of the size of this area, and I think Ms. Clark has indicated, and I think the evidence will show, it's a very, very small area given the circumstances. We will show that the police who came over to Bundy, you will see walking through that scene, went in that house and didn't take one picture. They went in the house, that they found candles burning and various other things, that the investigation inside that house was shoddy and scarce, if at all, under the circumstances. And so in this case, as with many cases, you'll recall that we talked to you a lot about truth and your common sense. During voir dire, I think all of us told you that we wanted you to use your collective common sense. And don't leave it outside in the hallway, to bring it in and apply it to the facts of this particular case. In applying that common sense, as I indicated to you, you'll look and you'll be able to see this small area. You'll see the fight that Mr. Goldman put up. You'll see the injuries that he sustained. You'll hear the testimony about the amount of blood to be expected on the perpetrator. You've seen Mr. Simpson's body, the lack of scratches thereon. You'll see, and your common sense will address, based upon the evidence, the issue of whether one person could kill two people under these circumstances without hearing
I hope you're
screaming
doing well.
and a lot of running and all sort of things. We expect, hopefully, that the evidence presented by the defense will help you provide some answers to these common sense questions. Expect also that you'll hear from a witness by the name of Paula Barbieri. She's, both sides are aware of it, and will testify about her relationship with Mr. O.J. Simpson. Specifically, as I mentioned earlier, between the period May of 1992 and May of 1993, and May of 1994 to the present. This case really boils down to a whodunit. So this case is about. It's not about domestic violence or whatever. It's about who killed these two people in these particular horrible crimes. Prosecution will probably start off with the domestic discord evidence. And that, with all the evidence, I ask you to keep an open mind. You know the circumstances. You know there are generally two sides to every situation. We cannot call our witnesses till we get our time in the part of the case where it's our time to put the witnesses on. That's why I've spent so much time in this opening statement, to try to detail for you what we expect the evidence to be and what we expect to show. You understand that the fact that someone has an altercation with one's wife in 1989 is not capable of being predicted whether that person would kill her, be involved in any other fights, or whatever.
Sustain.
And so I started off by indicating to you that I thought this case would be a case where we would establish this as a rush to judgment by the prosecution, and they had theories and speculation. We would have the facts.
I assume these are the concluding remarks.
Yes, Your Honor.
Thank you.
Thank you. They would have theories and speculation, and we would have the facts. That I was trying to conclude what I was saying when she interrupted me. Your Honor. In this instance, in this case, both sides are interested in this search for truth. That's what a trial really is. It's a journey for truth, for you to determine the true facts of what happened on June 12, 1994. We spent a great amount of time in selecting each of you for this task, because we knew it would be a very significant task. And in truth, I'm always reminded of something that James Russell Lowell said. The truth forever on the scaffold, wrong forever on the throne. Yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. And in this case, God knows what happened on June 12th.
It's argument, all of it.
This is not argument, Your
It's a
Honor.
closing comment. Thank you, counsel.
Thank you. God knows what happened on June 12th, 1994. And we hope that after you've heard all the evidence in this case, you can make a rational decision, and you too will know what happened. And you will know that O.J. Simpson,
Objection, Your Honor.
He can say that that's what he intends to prove, counsel. He can say that.
Thank you, Your Honor. You will know that the evidence will show that O.J. Simpson, that man pictured over there on June 12th, did not kill his wife, did not kill Ron Goldman. And he is entitled to an acquittal. Thank you very much for your attention. It's maybe the longest opening statement in the history of this building. But I appreciate your patience and the fact that you took the time to listen. Thank you.
John, listen. It's not over yet. We're not starting trial yet because she gets to stand up. Well, probably she, right? You think she's going to stand up or someone else? Prosecution gets to stand up and do another end opening statement too. So let's just try to get through it.
All right, thank you, counsel. Deputy McNair, we're going to take a break. Let me see counsel without the reporter before we do that, though. All right, ladies and gentlemen, we're at that part of the trial where we will now, this afternoon, start the presentation of the witnesses and evidence to you. As I mentioned to you, before we actually started the presentation of the witnesses, we needed to do a little moving around of materials and things here in the courtroom. We're going to do that, and I expect to start with the witnesses in about half an hour. All right, so I'm going to excuse you to go back up to the lounge.
Yeah, that's not happening. What do you think?
Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions. Don't talk to anybody about it. Let anybody talk to you. And we'll see you back here in about 30 minutes. All right? All right, counsel, I'd like to...
Oh, maybe I'm wrong. Nope.
Made other statements to other parties indicating that she had no awareness of any unusual events that transpired that night, and that her story was so
What in God's name is going on now? What is she talking about? Why isn't the jury here? Why isn't the trial starting? What's going on?
incredible that when she attempted to sell it to the National Enquirer, they declined to print it. and that we would have told the jury about all of these things, about these witnesses, had we
So
been
we're going to
informed.
have a trial about the credibility of the National Enquirer?
No, we're going to have a trial about the credibility of witnesses who are so uncredible that even the National Enquirer would not use their story.
That's hard to believe.
It tells you how uncredible, but it certainly tells the court how uncredible that witness is, if even they decline to use it. And that we would have informed the jury of those witnesses and of those facts, but we were unable to do so because counsel willfully withheld them. Thirdly, with respect to the rheumatoid arthritis, the chronic and acute phases described by counsel, that again, these witnesses were not disclosed to us, and no statements were disclosed to us indicative of the possibility that they would be called for the purposes outlined by counsel. And had we known, we would have shown them the videotape of the workout tape made by the defendant 2 weeks before the murders, and we would like to show them some of the outtakes of that videotape.
He made a workout tape 2 weeks before the murders, and they're claiming that he is disabled, so he couldn't have committed the murders. And he went golfing. Okay.
And finally, to correct counsel's entirely misleading, misrepresentative statements concerning the EAP markers on the victim's blood and victim's thigh and onto her nails, counsel misrepresented the nature of the report to the jury in a manner that is so confusing and misleading that if we have to wait until that testimony is forthcoming, the jury will be hopelessly lost. The problem is that we have a diametric opposition between the report and what was actually said to the jury by Mr. Cochran. The report indicated that the B-type that came up on EAP marker was inconsistent with any of the three parties, and went on to state, which is what Mr. Cochran never let the jury know, that that did not rule out Nicole Simpson as a possible source, because her type being a BA, this is a very labile marker, which means that, in essence, the A falls off when there's degradation. That there was, in fact, evidence of degradation of this blood because her hand was found clutching her neck under her body where the blood was warm, very wet, and very subject to degradation in a rapid manner, which is what caused the degradation from BA to B, and that's what the report reflects. Moreover, counsel directly misrepresented the conclusion of the expert with respect to the blood on the thigh. That blood indicated a faint A activity. It was a faint A activity that is indicative of the possibility that it was her blood, it was consistent with her, and so the conclusion was inconclusive, not that it was not consistent with her at all. So right now the jury is sitting there having been totally misled as to the nature of the findings. Not only that, and misled as to the contents of the report because counsel excerpted portions unfairly. I understand counsel doesn't have to read the whole report, but it should be read with respect to all of the conclusions, not just the one that suits counsel with respect to this particular item of evidence, and that's what was unfair. We would ask leave of the court to inform the jury of the fact that they were misled, that the report actually states as follows, and to highlight all of the portions. At this point, Your Honor, counsel's statements to the jury have caused, because of the national televised nature of this trial, the whole country's been misled as to the truth. The truth has been hidden, has been obscured by counsel willfully. Counsel knows the truth. Counsel knows what we have in this blood. Counsel knows that the PGM subtyping has shown that it is her blood. And counsel knows that tests are ongoing that will further establish that it is her blood under her nails and on her thigh. But we have a whole nation now who has been misled as to the nature of this evidence. But more importantly, that this jury has been willfully misled. And
Not a whole nation. Not a whole nation, Marcia. The whole world. The entire world.
and been made to believe that the conclusions were diametrically the opposite of what they really were. So we would ask leave of the court to address the jury with respect to that item as well.
Let me ask you this, Ms. Clark. Let's take it from the top. As to Ms. Gurchis, there is the claim of right to reopen since there was no notice given of this person's statement. This is the person who was alleged to have seen 4 individuals in the vicinity leaving the scene roughly at a time consistent with this particular crime. So obviously this is an important witness if this testimony pans out. What, in your offer of proof, do you believe shows lack of credibility and would be...
Those are calendars. January, February, March, April, May, June.
...be admissible as impeachment evidence I mean, you've given me, the fact that somebody has 34 pending lawsuits against them doesn't necessarily mean that they're not a credible person. I mean, they could be all car crashes for all we know. I don't know.
May I address the
I mean,
court?
other statements that are inconsistent, that sort of thing. I mean, that's a different issue. It has to go directly to credibility, other bad acts.
Yes, I appreciate that, Your Honor. With respect to those lawsuits, we will be calling witnesses to testify to the fact that they were for fraud, which does go directly to credibility.
How many of these lawsuits are actually final with judgments rendered against Ms. Gerches for fraud or fraudulent activity? Because I'm not willing to litigate 20 other lawsuits if there isn't some verdict in them.
We could simply call the parties to the lawsuit to indicate why they've sued her. They would indicate that, I believe with respect to almost all of these lawsuits we're talking about, all 34, they all deal with fraud and misrepresentations in the operation of her business. And
Well, do we know how many of these have resulted in verdicts?
I'm sorry? I can't hear you,
Do we-
counsel's talking so loud.
Do we know how many of these cases have resulted in
May
adverse
I
verdicts?
may I
Certainly.
inquire, Your Honor?
Certainly. Judgments, verdicts, same thing.
We have,
Not for this purpose.
because counsel has hamstrung us by hiding this witness, we have not had a great deal of time to complete the investigation. And we have obtained a list of all of the, it's what Mr. Darden is holding right now, a list of all the filings that have been made against her, but we have to investigate each and every one to determine the resolution of each one. If counsel had given us this information in a timely fashion, Your Honor, I could have stood here before the court and explained and given the answers to all of this a long time ago. But it's been 7 months since they took the statement, and we just got the notion of her existence last week.
Well, Ms. Clark, then, since these revelations on Wednesday, you haven't sent a law clerk over to the Civil Index to go check the status of all these cases?
We are checking many different, we are making checks on all of the representations of counsel. There is a lot to check, Your Honor, and with Rosa Lopez as well.
Wouldn't you say this is a rather key place where you should focus your effort?
It's one of them, yes, and we have been. We have investigators out right now, and we have had. That is one of the many areas regarding Ms. Gerches that we are investigating. But there's a lot to investigate in Ms. Gerches, a lot. Not to mention the 3 Social Security numbers, the 3 phony names. Right in front of us, we have 4 judgments shown. And we have additional paperwork that we're going through upstairs as we speak.
So what are you asking for me to do? To delay these proceedings until you complete your investigation?
I don't think it's asking for very much to ask for some additional time to be able to present to the jury an opening statement that comprises all of the facts, since it is not our fault that we didn't have time to investigate this person.
All right, let me ask you about Rosa Lopez. My recollection is that her name does appear on the defense witness list and that you did have information regarding her previously. Is that correct?
Yes, we had limited information regarding her. We have new representations made by counsel that indicate that there are other statements that we are not in possession of. The actual statement given to us by counsel indicates that what she told Detective Furman was that she heard some noises last night. That's all it says. Counsel made representations that she told Detective Furman that she was out at 10:15 and saw the Bronco on Rockingham, that she was out earlier at 8:30 and saw the Bronco on Rockingham, that Detective Furman was in possession of all of these facts and all of those details, when in fact their own witness statement indicates only that she told Detective Furman she heard some noises last night, period. No mention of a Bronco, no mention of being out walking her dog, no mention of seeing the Bronco anywhere.
When did you receive this
That statement?
statement?
We freaking love clown shows. Yes, we do.
September 1? So what counsel represented as having been stated by this witness to the jury is not at all what was contained in the witness statement that he gave to us.
All right, here's one of the difficulties, Ms. Clark. You're arguing Rosa Lopez. This is the first argument regarding Rosa Lopez from the prosecution point of view. She was not part of our discovery sanctions motion, to my recollection.
She
So,
wasn't.
She was not.
No, I know. I know, Your Honor. Yeah. We had to go through the transcript. You have to, Your Honor, when you tell us to go and do something, it doesn't just happen like that. We have to go up and we have to work. We have to go through the transcript. We were up all night.
Counsel, here's the
And
problem.
what we found is that when we went through the transcript, we found that there were many different statements attributed to her that we did not have.
Here's the problem. We took our recess to do that. I asked you to go through the record and find all of these discovery transgressions that you could find. The problem that the court has is I'm just the referee here. I'm not privy to what information either side has. You know.
I think he's way more lenient towards the defense. I don't know why I think that. I can't pinpoint specifically why. I just feel like her objections are overruled. I mean, like, her objections are overruled and his objections are sustained more. Maybe I'm wrong.
The details of your case, you know what you have in discovery. I have no idea. I went through the record. I found the names of the 14 witnesses whose statements were given over last Wednesday. I went through the record and found the expert witnesses who were discussed that had not previously been disclosed, or it was unclear from the record who they were, and those that you objected to. Now you're raising an additional objection to Rosa Lopez that has not been litigated, and you're raising a different objection to the Mr. Cochran's statements regarding the EAP blood typing, correct?
Yes, well,
Neither of which was discussed previously in our sanctions motion, correct?
I did object on the blood before. I did. We went to sidebar, and I made an objection on the record to the court concerning the misleading nature of counsel's remarks. I'm on the record with respect to that, Your Honor, at sidebar. And
But see,
yeah.
part of the problem is that was part of our show and tell, where that was exhibited to you, and you had no objection to that exhibit. That's why I overruled your objection. There were 2 days where counsel exchanged exhibits, showed them to each other, and it was a little late in the middle of counsel's opening statement to then start lodging objections to an exhibit that both sides had seen and had waived any objection to. That's the problem.
No, but I did not realize that counsel was going to excerpt a half of a sentence, which is what he did. I'd like to, if I may, Your Honor, I'd like to show the court what I'm talking, because the court doesn't realize there's a paragraph. Counsel took out 2 lines from that paragraph, and it actually is, I think the court should see it. I really do. I think that if the court sees it, it will realize I was misled. I thought this entire paragraph was going to be shown. If it had been, I wouldn't have objected. But it wasn't. As a matter of fact, another thing that happened, Your Honor, was that I was shown the front page of the coroner's transcript, and I believed that that one area was going to be highlighted for the jury on that front page. And lo and behold, in front of the jury, I see counsel going after page after page after page, which I was not told about. I didn't bother to object, because I didn't want to interrupt the opening statement any more than I needed to. But as a matter of fact, I was misled, both with respect to this and with respect to the coroner's report. Counsel put in a lot more, or in this case, a lot less, than what I was led to believe he was going to do.
Well, Ms. Clark, let me ask you this, though. After we spent 2 court days doing a show and tell, and you waived your objections, I mean, how am I supposed to go back and now revisit this and allow you to reopen opening statements? Because so far, the only thing that we've talked about that remotely approach being able to reopen on are your comments as to Ms. Gerchis, as to judgments against her, and the exercise video contravening the arthritis experts that had not been previously disclosed. But Rosa Lopez is an objection just now being raised, and the EAP is something, although you did raise that objection earlier, I think you waived that objection having passed on the exhibit.
I didn't pass on the exhibit, Your Honor. That's the problem. That's what I'm trying to explain to the court. Number one thing, let me get back to Rosa Lopez. As to Rosa Lopez, she was mentioned by counsel
No, no.
today.
If you're really
So-
worried about the EAP, let's quit jumping around. Tell me about the EAP and why you feel you were misled.
I think what the court doesn't remember is that we were supposed to have show and tell on Friday, and counsel only showed me a tenth of what they had. We came back in on Monday, and at the 11th hour, before we were to begin our opening statements, counsel sprung 20 new boards on us, and then pulled out the reports. Those reports were not shown to me on Friday. And to the extent that I was shown the reports, the coroner and this one, I was misled as to what they were going to use. And only when it was showing before the jury did I realize what he intended to do. I made the objection as timely as I possibly could. The moment he did it, I was overruled. Nevertheless, I was misled. And if I show the court how this paragraph appears, I think that the court will understand why I was misled. Counsel pointed to this portion of of one particular result on this page, and I believe that it was going to be fairly exhibited to the jury in context.
All right, why don't you read it for the record?
You know what? If I could use the Elmo, I can show it and read it at the same time.
By golly, let's do that.
The part that I've drawn, Your Honor, the bracket around, that's the item in issue. Item 84A. I need one. And 118A could not have come from Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson. However, Nicole Brown Simpson cannot be excluded as a source of the stain if the EAP type B observed on the items were degraded from a type BA. Now, there will be substantial literature, Your Honor, to the effect that a type BA...
All right, let me see. Mr. Harris, is he available?
Your Honor, we went through all the laser discs, and we only had the highlighted portion that we show on two boards. One with the cover highlighted, and then pulling out the highlight. We only showed the laser board. All of our presentation was shown.
Your Honor, I don't even remember seeing a laser on this. All I remember having counsel tell me was showing me a report. You know, I would not have taken counsel to sidebar and objected to something had I known what he was going to do. As a matter of fact, I would have objected strenuously ahead of time had I realized that he was going to take one line out of context, outside of a paragraph.
All right, you understand the difficulty I have here. I mean, you've been given an opportunity to litigate it, and now you want to come back and do it again. That's my problem. Where's Mr. Harris?
I'm going back to the office, Your Honor.
My dog says I'm done, but I'm not done. I'm gonna keep going a little bit longer, even though I do everything my doggie says. She'll be fine for a little bit. She's a poodle. She's a poodle beagle, and she is so smart. She's the smartest animal I've ever had. And she's stupid, but she's smart.
We weren't about the laser disc would be used in reopening, should you permit it.
All right, Ms. Clark, there's really something that I can't deal with then if the laser disc itself, the exhibit that they showed you, is in fact gone, because I need to make a factual finding as to whether or not there was some, that you were misled in some way as to what it was.
I'll tell you, Your Honor, I don't recall seeing a laser disc.
Well,
There was...
Ms. Clark, let's look at the laser disc and see what's there, because that's pretty much frozen in its state. You know, that's not easy to manipulate, so let's take a look at it. Unfortunately, we probably won't be able to see it for quite some time. Since Mr. Harris is on his way, we'll have to catch him and bring him back.
But, Your Honor, I can represent to the court that we did not have the document here on Monday. We had only the laser disc, and the court required that we go through and show everything.
Which is why, Mr. Douglas, I'd like to see the laser disc.
You should have tried
But
my
why was
ex.
it only being shown to us on Monday? Why wasn't it shown to us on Friday?
No.
No, I'm
Ms.
serious.
Clark.
You know something, Your Honor? This is very unfair. The defense was required to show all their exhibits to us on Friday, as we did for them. We sprung nothing on them. They came marching in Monday with twice as many exhibits as we were shown on Friday. We were expected to absorb everything in a nanosecond and come up with cogent objections to each and every item. And that's very unfair. The people were put at a great disadvantage at having to absorb a great deal in a very rapid amount of time.
Again and again and again, they keep doing this.
And come up with an objection as to each and every item. I don't think it should be all that surprising that I couldn't remember seeing one of about 50 new exhibits that was thrown at me Monday morning before our opening statements were to begin. And that alone should cause the court to realize that the people were put at a disadvantage with respect to being able to make intelligent objections to all of the wealth of new information that was unjustifiably thrown at us at the 11th hour. We should be given more time at this point.
Did you ask for any additional time at that point?
I did, and the court was... I indicated to the court at the time, Your Honor, that I did not have an opportunity to examine it carefully, and you asked me to immediately go through board by board and exhibit by exhibit with about 10 seconds for each. There really was not a lot of time. The court is concerned, I understand, about having the time of the jury spent fruitfully, and I'm mindful of that, and I appreciate that. And the court, was feeling the time constraint, understandably so, and so was I. But the result of what has been misconduct by counsel in failing to turn over exhibits in a timely fashion should not inure to the people's detriment, as it has been. And I think that's very unfair.
So you're saying that last Monday, the 23rd, just so I can check the record if I have to. All right. I'm not going to take up that issue unless and until I see the actual Laserdisc exhibit, which has unfortunately left the courtroom. That leaves me with Gurchis and the arthritis experts.
Okay, and with respect to those witnesses, which the court knows we were not informed of, either their names or their statements or their proposed testimony, we would ask leave of the court to address the jury with respect to the fact that we were not apprised of their intention to call such witnesses to describe the defendant's physical condition at the time of the murders, and that had we known, we would have discussed that with the jury at greater length, putting on the exercise tape. Now, counsel showed us photographs of the defendant's body that they intended to introduce, but those photographs gave us absolutely no notice that they were going to be presenting testimony concerning rheumatoid arthritis. The existence of Howard Weitzman, that was another matter that...
All right, behave. I'm going to step away for 2 seconds because I have to. It's been a long time. I'll be right back. Enjoy the show.
That was not turned over to us in discovery. The name was not even on a witness list. Had we known that they would make these representations to the jury that Mr. Weitzman was excluded from the conference room, we would have been able to address the jury on the fact that not only did that not happen, but the officers are very well aware that would be a violation of law. As a matter of fact, it's something that is contained in the Miranda advisement, that Mr. Weitzman was in fact pointedly invited in with Mr. Simpson, that he declined to remain with Mr. Simpson, and himself decided to leave the facility. And we would have told the jury all about that. We would have even maybe read the Miranda advisement to the jury so they can understand that this is an obligation of the police to afford anyone who appears with his attorney the right to have the attorney present during questioning, and that Mr. Simpson was so advised, and that he elected to proceed without the presence of his attorney, and we could have done all of that. But counsel, as a matter of fact, we have that waiver on tape. Counsel's aware of that. But yet counsel deliberately chose to make a statement that was false to this jury concerning Mr. Weitzman. Had we known he intended to do so, and had we known that Mr. Weitzman intended to so testify, we would have put that before the jury. Furthermore, all of the evidence with respect to the circle of benevolence, the charity, and the gift-giving, we had no discovery of any of that, Your Honor. That defense counsel wanted to present that. And with respect to at least the representation of anonymous gift-giving to links, we believe that we will have evidence to demonstrate that to the extent money was given, it was not anonymously given. And we would like to present to the jury the fact that the amount given to charity was minuscule compared to the amount of net worth this defendant had. And so we would like the opportunity to counter some of that evidence, which was also still has not been turned over in discovery. Still, only knowledge we have of that is the representations of counsel in his opening statement to the jury. Furthermore, with respect to Skip Taft, I believe counsel, again, this is another name that was not put on the defense witness list, for whom we have no statement, but counsel represented that Mr. Taft would testify concerning the contents of a prenuptial agreement.
Is there any dispute about that?
I believe there is. May I have another break? There were certain representations made with respect to what Skip Taft would testify to in that prenuptial agreement, that he would testify to the circumstances surrounding it, and it was represented to this jury as being another act in the circle of benevolence, that in fact it was a civil compromise attempt and nothing more by the defendant in an effort to get to pressure Nicole to withdraw her support for the prosecution of that case. And we would like the opportunity to address the jury as to the truth of the circumstances under which it was written. I just can't, it doesn't come to mind at this moment. But that's for starters.
Mr. Bailey?
If it please the court, in asking this court to set what I think would be a precedent in criminal cases, the prosecution now wishes to escalate that remedy to a full-blown rebuttal of things they wish they thought of when they gave their opening statement. They knew before they opened that Mr. Simpson intended to exhibit his scarred and torn up knee to the jury and claim that he was disabled to a degree. They had the exercise tape. They elected not to play it. Now, in retrospect, it seems a bad idea that they didn't. Since you have stricken from our opening the names and any summary of what they might say of the witnesses enumerated in your order, it seems to be most anomalous to silence us and let the prosecution get up and trash them without rebuttal, making wild statements like Rosa Lopez is an O.J. Simpson fan when she's never met him, or Nicole. Furthermore, all this claim of surprise on Rosa Lopez is totally incredible. You will recall that as part of our offer of proof in response to the government's demand to you, we cited two preliminary incidents, both occurring on the 13th, which showed bad faith on the part of Mark Furman. One was the glove, and the other was suppressing a statement that Rosa Lopez had given him. It was in the papers. It was faxed to the government on Sunday the 8th. It was argued orally here and was in part, I guess, the basis for your ruling, together with the Anthony case. Mr. Cochran, long after the statement was taken and before this representation was made to the court, personally wanted to verify that she claimed that she had made those statements to Furman. And on that basis, we asserted it to Your Honor. I never heard it denied in the course of the whole argument. I don't think Rosa Lopez is any part of any reopening. Perhaps, perhaps as to Gerches, if some admissible information can be gotten, the court might permit this now thoroughly trashed woman who's never had a day to appear, although she's expressed an interest in doing that, to be impeached. If, in good faith, they claim and they, as officers of the court, assure you that they will produce on the witness stand under oath people who will testify that she has made the statements attributed to her. I'm not talking about judgments now or check cases. I'm talking about impeaching statements. If those representations can be made in good faith, perhaps, Your Honor, might permit them to talk about it. I haven't heard another thing in all of Mrs. Clark's presentation that makes any sense at all as reopening as a remedy for the sanctions, as part of the sanctions you've imposed. Insofar as the blood evidence is concerned, we have an assertion of fact could not have come from Nicole Simpson, an attempt to bail out by somebody who obviously is in the prosecution's corner, speculating that if the blood were degraded, AB might have shown up as B, and therefore that would explain it without bringing in another party. We showed that on the screen. It's in the statement. If we had it to do all over again, I don't think any court could compel us to link the author's speculation with his...
Oh, I don't have my microphone. He just has a really good voice, so we're going to believe him.
established fact, and that's all that second sentence is. We pay it no importance at all, and we don't think that it's going to pan out. But in any event, in opening statement, we're entitled to show the jury those things that favor us. Now, apart from Ms. Gertsch's, I don't believe Your Honor should permit any of what has been requested by the prosecution. It is nothing more than a chance to come back and rebut the defense opening statement. They could have handled all of these matters beforehand if they had thought about what they were doing as carefully as Mr. Cochran did when he laid out his very detailed presentation.
Which he only showed them minutes before.
With respect to the blood argument just given by Mr. Bailey, he demonstrates nothing but his ignorance. As a matter of fact, what Mr. Matheson put in that report is a matter of established science. We are talking here a matter that is the subject of treatises that are many years old. It is a known fact that the EAP marker is very labile, that a BA degrades to a B very rapidly, and the court can envision it. You have 4 bands in this marker: heavy band, faint band, heavy band, faint band. The faint bands are A, the heavy bands are B. The faint band, being A, degrades first. BA goes to B very rapidly. It's a known thing, which is why when there's evidence of degradation and you have a B result on the EAP, you cannot exclude the BA. And that is something that the jury has been completely misled about. Not to mention the fact that at least on the thigh marker, where counsel told the jury that it excluded her as well, there was faint A activity. So, I mean, there's been
I'm not prepared to really make a ruling as to the blood issue until I see the laser disc exhibit. to see whether or not there is some real danger of the jury having been misled there. I'd like to hear your observations on Mr. Bailey's argument that you were aware that there was going to be some allegation that Mr. Simpson was unable to, because of his arthritic condition, unable to physically to even contemplate committing these acts. Why it didn't occur to you, knowing that, to play the exercise video during your opening.
When did we know that, Your Honor? When does counsel allege that we knew that?
My towel warmer is one of the greatest things I have.
The motion was made for the defendant's right to address the jury during opening statement.
Which was on Monday.
Right.
Which we objected to.
Before your opening statement.
That's right, which we objected to. But being able to show a scar, which is what my argument was to the court at the time, has nothing to do with doctors who are going to testify to rheumatoid arthritis. There was no offer of proof forthcoming with respect to how that scar was going to be linked up. I repeatedly argued to the court, what is the probative value of showing the jury a scar? Believing that that's all that the defense would do, I elected at that time to let it be. Because I did not think that counsel, because counsel did not give us discovery. This is the problem with being sandbagged, Your Honor. Counsel never gave us discovery of the fact that the doctors were going to be rheumatoid arthritis specialists, were going to come forward and link up that scar to something meaningful in terms of his physical capabilities on that day. And counsel deliberately and willfully did not inform the court or the prosecution of his intent to link up that scar to a doctor's testimony. Now, how was I able to anticipate what counsel was going to do when he willfully withheld that information?
All right. Now, Ms. Clark, let me ask you one other thing. Can you make an offer of proof to the court that you will have witnesses, as to Ms. Gerchis, who will testify to inconsistent statements, such as telling other persons that she was truly not there, that she was not in fact looking for a condo or apartment in that area? Any other specifics regarding credibility, specifically as it comes to this case?
Yes.
Tell me about that. You can make that representation
Yes.
that you will have those witnesses.
Yes.
That sounded confident, that yes.
All right, any further comment, Ms. Clark?
With respect to Rosa Lopez, I can only indicate, Your Honor, that we were unfortunately sandbagged badly in that respect as well. Upon reading the transcript, I was stunned to realize that counsel attributed many statements to her that allegedly were made to Detective Furman on the morning following the murders, when in fact his own statement indicates that all she said to Detective Furman was she heard noises. It took an extensive and exhaustive review of the transcript to realize, to go back to find exactly what those statements were. And counsel then reiterated it again today to this jury, which compounded the harm in his failure to turn over that report, which we still don't have.
Right.
We still have no statement indicating that.
Mr. Cochran, is there no report about that?
Absolutely none, Your Honor, if I might respond.
Then how do we know that then?
Because we went and talked to the witness, we talked to her, they had the report, when we got the report, Your Honor, they had this is a key witness, obviously. They know that she talked to Furman that morning. Don't they have an obligation, do have to do their job also, Judge? Don't they have an obligation to talk to Rosa Lopez like I did? There's no further report. That's the thing that's so amazing about what they're saying. We don't have to do their investigation, Judge. We're the defense in this case. We don't have to do their investigation. This is unprecedented. We have them whining and moaning. These are just opening statements. We haven't even started the trial, Judge. And all this emotional, vitriolic, everything is misled, and everything they do is perfect, everything we do is wrong, and we are just doing our job, Judge. And it's absolutely incredible that she sees all these exhibits and all these things and wants to rehash everything with you, Your Honor. We offered that these things should be over at something. We ruled on the other things. Yet we have to relitigate everything over and over and over again, Your Honor. And I don't think that's fair. It's not fair to Mr. Simpson.
Okay, we have to stop here because courts are opening. I got work to do. I have to get my courts in, or I don't have a live stream. It was a good word. It really was. It has nothing to do with anything that's going on, but he used that word, so everybody should believe him. We thought he was done talking, but he is still talking. And I would love to wait for him to stop talking to pause this video, but damn, we would be here forever. We would be here forever and ever and ever. She just threw those papers down like she wanted to, didn't she? Sevo, thank you so much for coming out. I love when you come in. I do, I do, I do. Yeah, we would be here for another hour. Guys, stay warm. Okay? Just stay warm. Now, remember, I don't know if I'm allowed to say this. I'm going to say it anyway. If you give a man a blanket, you can keep him warm for an hour. But if you set him on fire, you can keep him warm for the rest of his life. Words to live by. Thanks for coming out, guys. Love you. Bye.